Hey guys, good evening here from Raleigh, and maybe afternoon where you are, or night, or whatever. Well, let's take a look at this Delphi case, and more specifically, what's going on at the state Supreme Court level. It may be a little confusing. It was to me until I looked it all up, because as you know, there's been some big drama procedurally in that case, with the judge first announcing that the defense counsel had withdrawn, or they were one of them was going to withdraw, and then saying they're disqualified out of the case. And then those defense counsel, Baldwin and Rossi, saying, hey, we'll do it pro bono, okay? You don't have to have us as appointed counsel being paid. We'll do it for free. And she said, no, you're disqualified. So that has set off kind of a firestorm in the case, and let's take a look at it. Let's see, morning. So that's interesting. Yeah, that's cool. You're ahead of me, I think, or behind me. I'm not sure. Depends on what day it is where you are. Yeah, 5:30 this morning or something earlier. That daylight savings time thing is always screwing things up. So there's two actions at the Indiana Supreme Court. Okay, so there's two different petitions filed for writ of mandamus and prohibition, and we'll look at both of those, but there's two of those. The first one, 302, that is to make certain documents public, and that was filed before this latest hearing. And then also to prohibit document removal from the chronological case file and the case file itself. As you may remember, the judge said, hey, these latest filings by Rossi, I want those taken out of the case file and struck completely from the record. So this action is meant to undo that. And David, making law simple. Glad to have you aboard. And if you see anything I'm making a mistake on as we move through this, please pipe in. So that was the first action. It was very limited, and we'll talk about that when we get into it in terms of maybe what the strategy was for that. And then there's 311, which really gets to the point of this thing, which is that action says they want Baldwin and Rossi reinstated, and they want the judge removed, and they want a speedy trial. Now, these type of actions, this petition for writ of mandamus and things, these are rare, and they're not a substitute for appeals. This is not a normal appeal, okay? This is going straight to the state Supreme Court saying that you need to order this judge to do something or to not do something. And as you can imagine, if you let lawyers do that every time they didn't like something a judge did, the Supreme Court would never be doing anything but hearing these petitions. So these are tough to get, and they have a lot of specific requirements to even get them considered, and then they're harder to get the Supreme Court to actually act on it. But this is an extraordinary case, and it is for extraordinary circumstances. So I think we're looking at something that could be very real here. And you may not be able to read this, but I'll try and tell you what it is. The small part on the screen is an email from Judge Gull that was sent to Baldwin, Rossi, and the prosecutor on the case at the time. It was found out that the images had been leaked, and I think after the tragic circumstances surrounding that. So the judge says this is beyond tragic. Once again, I'm at a loss for words. I'm deeply concerned that Mr. Allen's defense is being compromised by all these recent events. I will have my staff schedule a hearing in Fort Wayne for next Thursday, October 19th, to discuss these recent developments in the upcoming hearing on the 31st. I'll have a transport order for Mr. Allen to the hearing. Please arrange your schedules accordingly to appear in Allen Superior Court. Mr. Rossi and Mr. Baldwin, please cease work on Mr. Allen's case until we meet on the 19th. So I remember when I heard that, and I was like, what? That's weird. Well, these things were occurring, of course, in the background, not on the record. So, I mean, and sometimes that happens, and that can be okay, but it isn't okay for everything to happen off the record, or why would you need a record? So it's not good how this evolved from this point. And then you can see part of the transcript from the 31st. And the top part of that is when the DA is talking to the state attorney. And I note in here that he says, and he talks about the Franks motion and how it has a lot of things in it that aren't necessarily related to what's relevant for Frank's motion in the state attorney's opinion. But he says, I think everything they've done, including the most recent leak, is just an effort by them to push this case out into the public and try this in a public eye and not in his court. He's talking about defense counsel. Now, that sounds like to me an allegation of intentional conduct, okay? You're intentionally inflating your Franks memo to put a narrative into the public eye, the DA says. And he also says, including this most recent leak. So that's quite an allegation to say that this is part of their effort rather than something someone else did that he shouldn't have done. And so they say the state has a concern that Mr. Allen has a fair trial, but the state should have a fair trial too. And of course, that's true. And then he says, I don't think this can be attributable to anything else but gross negligence. And that's the state's opinion. Now, there's a difference between saying that you have a deliberate plan to put everything into the public eye, including leaking discovery, and gross negligence. Those aren't the same things, right? I mean, gross negligence is not the same thing as intent. So I'm not sure which one of these he really means. And I got to feel like perhaps the gross negligence words came from the judge first, and he's just mirroring that. So here's a question here, and we'll get into some of this. So if the judge said the lawyers are off the case and they quit and they bolted out of the courtroom, should their later filing still be on the docket? And in my opinion is generally, yeah. And then she can say why she's not going to consider it. And for example, sometimes you'll see somebody try to intervene in a case and they'll file something and the judge may allow it or not allow it, that sort of thing. And plus, remember in this case, Rossi left the courtroom, but the judge said he's going to be filing his paperwork for a motion to withdraw. So that to me assumed that he was going to be filing something else and he can never file anything else again. So this is kind of strange. And we'll get into this a little bit. And I will hit this too since I see this. Thank you to all the veterans around the world. And I certainly agree with that. I met so many good people in the military, and we wouldn't have the country we have if they weren't there to begin with. So that's not down to me, that's down to them. But it was my privilege to meet some really good ones. So there's also a question on here, shouldn't have argued this before withdrawing. Okay, and that's a good point too. And when I get off of this slide, I'll try to address it. I won't forget it. All right, so here's what the court says on this slide. Mr. Allen, I understand that you wish to have Mr. Baldwin and Mr. Rossi represent you in this matter. I have grave concerns about their representation of you, the previous findings by this court of their gross negligence. You're entitled to adequate representation in your case. You're entitled to a vigorous defense in your case, and this is difficult, Mr. Allen, because I know what you want. You've indicated through your attorneys, and that's this letter that he posted through them saying he wanted to keep Baldwin and Rossi. But I cannot and will not allow these attorneys to represent you with the concerns I've had with the gross negligence that I found. They withdrew rather than be found grossly negligent and be removed. So this is kind of like talking above in terms of, well, are you saying this is intentional or are you saying this is negligent? And originally this thing was, there was an in-chambers meeting and the attorneys come out and one of them goes to the courtroom and leaves, and the judge comes out and says, hey, they withdrew. One of them will be filing paperwork. That's the end of that story, kind of, right? Then, of course, Rossi comes back and says, no, I'm not going to do that. And so at that stage, I think you have the issue of, okay, well, hey, did you withdraw or did you not withdraw? That would be the question, right? And a couple of things on that. One would be the method of withdrawal that they used orally in the judge's chambers, and with one of them and the other one saying, I will withdraw. Does that comport with the rules? Is it effective? And of course, their argument that, well, you were coercing us into it. We were backed into a corner with really no notice. That's just an argument about whether those things are correct or not. You kind of need to know what was said, I think, in chambers, which I think eventually you're going to find that out, to address that issue. But then it evolved, right? Because the judge also said here, they withdrew rather than be found grossly negligent removed. So she's saying that they withdrew. Well, okay, so if they withdrew, why can't they come back to the case if they haven't been found anything? And now they're coming back pro bono, not appointed by the state. And then she said, no, you're disqualified from being on this case. You're grossly negligent. So that's a different issue, right? That is now saying not only am I going to say that you withdrew, and we can have the discussion about that, but now I'm going to say you cannot be on this case. And then in between that is when she said, anything you file, by the way, I'm directing the clerk to strike it completely off of the record. So this kind of stuff right here is a little dicey. Now, is it possible the judge has more information than we know about the attorneys? Of course. And certainly I learned some new things in just reading the filings that's up at the Supreme Court, and I'll try and point some of those out to you. And that was my point back, when this was happening on the 19th, is you kind of got to know what was said in there to really know the status of these arguments and what's going on. But I think that's going to come out. So I think that will happen. Now, I think from the judge's email here, she was over it when she found out that these pictures of the victims of Abby and Libby had gotten out. And then, of course, what happened after that. And she was steaming hot. And I think that's fair. Okay. And then she looked back at that, and I think the email that maybe Rossi had sent out, or Baldwin, one or the other, that they shouldn't have, just to the wrong person that had an index of discovery, but not actual discovery. And she said, enough's enough. Okay, so I can understand the emotional reaction because you're thinking about the trauma, the family finding out these pictures got out there like they did and circulating around. Even though the defense says, hey, that's going to happen, that isn't always true. But you're the judge. You're not just there to be angry. And there are certain ways to come to rulings and certain parameters for those rulings. And trust me, I'm not soft on this because I don't really buy the Odin thing as it stands. And I think the state has a reasonable circumstantial case. This isn't to the trial level yet, right? So you can't say whether he did it, he didn't do it for sure either way. But the defense was certainly putting up a vigorous set of arguments on behalf of Mr. Allen. So to see them go away only a couple of months before the trial, well, that's a big deal. And we'll kind of talk about that a little bit. But I want to catch some comments here, so let me slow this down. Yes, the judge called the leaks beyond tragic. Her clears her feelings are about the death related to the leak. And the leak of minor children. Yes, I totally agree with that. And to totally understand being angry about that. I don't dispute any bit of that. And, I don't have to think, oh my God, the judge is an Odinist and she's in on all this too, to think she's a human being and exercise judgment there that perhaps wasn't the best judgment, but it doesn't mean she's part of a vast conspiracy or whatever. Maybe so, but I don't think so. Anyway, we'll see what is going on here. But I have to say, okay, so somebody's reporting. I'm in Australia. It's the 11th here. We acknowledge Remembrance Day. A minute of silence. Of course, Veterans Day is even from, the people that just served here. So that's cool. And I always like it because it reminds me of the good old days. All right. So let's get off of the slide. This was just kind of to lay a little background anyway. So let's look at the first action, action 302. Okay. Because there's 2 actions filed. And remember, you are in technical land now. You are at the Supreme Court. This should be the height of technicality. They're there to review for errors. They're kind of like they should be a courtroom full of Spocks, right? And what's logical? We don't have a motion up at the Supreme Court. We're going to look at whether the rules were followed, the process was followed. And if it was not, then we will correct that. And if it was, then we'll let things stand. So you really have to dial that in a little bit. And it's not about anger or being butthurt or whatever. This should be as technical really as they're going to get. Well, interesting. They immediately essentially ordered a response by the judge by November 9th originally. So it was like, okay, they're going to look at this thing, right? That's a little bit of a clue there. They've got this written. They're saying, let's hear what you got to say and let's hear it pretty fast, right? All right. So then Judge Gull says, okay, I need some more time for this. I think she only asked for 5 days, and the Allen side said they did not oppose that. So the court granted an extension to November 16th. So that's when she has a response due to this first action. Now, action 311 is the second action that got filed. And that's the one that says, hey, put these attorneys back, kick her off the case, and give us a speedy trial date. Almost immediately after that was filed, they filed a motion for the transcript because they weren't getting it at the trial court level. And they want the transcript from the in-chambers meeting on the 19th. And I think that's very fair because everybody's wondering, well, maybe the judge knew this and knew that. And well, if she did, it would have been said then. So let's get this transcript out here. And if you're trying to justify kicking these lawyers off the case as I think the first sanction against them, then putting the information out there is probably what you're going to need to do to justify what you did. So the Supreme Court says, okay, respond by November 16th. And then on the motion to then they said, as regards the motion for transcript, either give the transcript over or respond saying why you aren't by November 16th. And then the judge said, hey, I need some more time for this. You already got me on one writ, and I need, I had to go hire my own counsel because the state won't represent me. And in this case, Allen's side said, we don't agree with this. I mean, get us the transcript. Okay, let's get this thing moving. And in the meantime, there's an amicus brief request by the Indiana Public Defender Council. We'll look at that. An amicus brief is just a friend brief. So it's like a concerned group or something like that has something to say on a case, and the court can, they're being a friend of the court to let you know more of a perspective that you might want court than what the parties are going to give you. Certainly see it a lot at the Supreme Court level, where there's all kinds of organizations that want to get on these, huge cases that are going to change the landscape of things around the country. But you see them at the state level as well, of course. And the court allowed it. So we'll look at that brief. And the court told the judge, hey, we'll give you till November 27th to do this, to do all these things, but don't ask for any more time. So looking at the comments here for a moment here. What if she isn't Odinist? What if she's in on the conspiracy? Most legal practitioners are Freemasons. Exactly. I may be an Odinist, right? I got this patch here. This is probably subversive now instead of what it used to mean. It was patriotic and things. So I could be an Odinist and not even know it, right? So that's how easy it can slip up on you. But I would prefer to analyze her actions, of course, just in terms of the most logical way that she could have come to them, which is getting angry about this. Okay. So, that's just an opinion. And it really doesn't matter. What really matters is, did she follow the rules, or did she deviate from them to such a degree that the Indiana Supreme Court should be stepping in and overruling her? And we're getting to it. All right. So we got the lay of the land here. She's got a response due on the 16th and a response due on the 27th. Unfortunately, the transcript's delayed potentially till the 27th. And beyond that, because she's probably not going to want to file a transcript, there'll be some argument about it. I think that's a mistake, personally, if that's what happens. But you can see from these time frames, the idea of a trial in January, that's been gone, and it's even more gone at this point because the court's going to have some time to think about all this stuff. So, yes, indeed, it could happen. So my scenario about it could happen that I'm an Odinist and she's an Odinist too. I totally agree with you. It's the weekend, so let's have a little fun with that. So let's get back to 302 and look at it in a little more detail. And this, as I said, is the first action is fairly narrow. It's saying the court has not treated the filings appropriately and according to the law and the rules by making them non-public, and also ordering the clerk to strike some of the docketed entries off the record completely and out of the case file. And it's kind of a long thing, but it really comes down to their conclusion here, which is if there was ever a time when the openness mandated by the trial rules was critical, it's the present case. It's so high profile. And what they say is the trial rules, access to court record rules, have been repeatedly violated, leaving the public and the media in the dark. A writ of mandamus or prohibition is appropriate to ensure that going forward, this court's mandates regarding public access are followed without exception. So in other words, stop hiding the documents, okay? Stop hiding the documents. There are rules for that, Judge, and you didn't follow them. And even though they concede, I think at some point they agreed with some of these things being out of the public eye, they say that's not an excuse for you, Judge, to be violating the rules because the parties can't agree to waive these statutes that apply to how the court should work. So how can they keep a transcript away? Good question. Well, there's no transcript yet. Okay, so it was recorded. What happened in chambers was apparently recorded, but it wasn't transcribed. And because the judge is saying that this is confidential, this was something we did back in chambers, not a public hearing, you don't have a right to get it transcribed. Yeah, we'll see about that. So that's, I think, what's going on there. So that's 302. Now, what's the strategy behind 302? And in my opinion, the idea for this when it was originally filed was to make this broad argument that the judge was messing up on classifying things as non-public, and then really messed up when she was striking things from the record. And they do talk about the dust up with the judge and stuff like that, but they're basically saying, put these things back on the record, put these things on the docket. And if you do that, then Rossi's filings are back in the game and the recusal motion is live, and the judge would have to deal with those, which in my opinion, she should have dealt with those in the first place. She should not have said, clerk, strike those from the record. She could have answered what he said directly and said, no, you're not in the case anymore, so the court's not going to consider it more. The whole striking thing, I don't think is looking good there. But this first step in this motion for writ for mandamus was just to force her to put these things on the record, because then if she didn't want to deal with them, they could come back to the Supreme Court. But of course, things happened after that, and we have some more. Yes, the 1019 and 31st hearings are transcribed very quickly. And I have no doubt that that what happened in the judge's chambers could be transcribed very fast. I think the judge is the holdup for that. The more things are hidden, the more suspicious it seems. that is a good statement, I think, and that's generally true. We all agree there are certain things that you just shouldn't throw out to the public sometimes. But when it's whole swaths of information, that's different. And when it's to a critical point of the case, right? Like you wouldn't want the actual trial, say, of Allen or any defendant to be totally secret and nobody knows how you got to a result. And I think likewise, when you're throwing the attorneys off the case and saying you cannot come back, that you got to do something more than just say, well, I think you're grossly negligent and we all know why. We all don't know why. We don't know why because you didn't put it on the record. That's what I think. So let's keep moving here through this. So that's my idea of their strategy, which was a very reasonable one in the first place, was let's get this narrow remedy. Because remember, you can't just go up to the Supreme Court and go, I don't like how this judge is acting, give me everything I want, or else that's all they'd ever be doing. So they very logically put this on a laser focus and said, here's what she's done specifically right now. We don't like a lot of things she's done, but what we're asking you to do is this narrow thing, which is to put these things back on the docket. And that would have activated what Rossi was doing. So that's what I see there. However, of course, we know that didn't really work out. And they had this public hearing and all the attorneys showed up and they're all pointing at each other. And the judge is like, what's happened in the last 12 days? Why should I listen to anything you have to say? And now we have the second action, which requests disqualification. Why did I write that? It's about the disqualification. They want the attorneys reinstated. It is about disqualifying / removing the judge, and then also a speedy trial date. So this is the real deal right here. And they open it up saying original actions provide extraordinary remedies and accordingly they'll be issued only where the trial court had an absolute duty to act. And they say the trial court had an absolute duty to reinstate attorneys Rossi and Baldwin, and the remedy on appeal is non-existent. And I think that's reasonable. I think that is reasonable. Let's say if the judge were wrong, you don't want to go through the entire trial and then find out you should have been allowed your original attorneys. You do not want that. You don't want that if you think the guy did it. Why would you want to put him through this process and then give him an easy appeal? So dealing with the issue now, I think, is the right thing. And the question is, are they right? So the right of counsel embraces not only the assistance of counsel, but also the reasonable opportunity to secure counsel of one's own choice. And remember, Rossi and Baldwin put their money where their mouth is and said, we'll do this pro bono. So they changed the game there, I think, a little bit. It was very interesting. So I'm trying to read these from the screen I'm streaming from, so it's a little bit tiny. And their argument is, listen, you can't just go around throwing lawyers out just because you don't like what they're doing. There are only a few circumstances where you can do it. One of them would be they're not a lawyer, okay? Or there's an actual conflict of interest that the court sees. And they say no Indiana court has ever tolerated a trial judge removing a lawyer from a case over the client's objection based on the judge's subjective belief the lawyer is negligent or even grossly negligent. I haven't seen it. So I've seen a lot of things, not everything, but many things. And I haven't seen this happen. So right now they're persuading me for certain. And here's where they put their arguments down. And I put compelling arguments because I think that they are. They say the judge had a responsibility, obligation, and duty to clearly articulate the basis for the motion. So having a private meeting, or the order, having a private meeting and then coming back at the end of the month and saying, I'm not going to let you be back on this case. Why not? The judge should have, in my opinion, put on the record at that point what the basis was. And the defense attorneys were ready to spar over that. If the idea was they weren't competent as defense attorneys, well, they were going to argue that. They were going to argue about what they'd done on the case, how they handled it, and things like that. So the judge just didn't do any of that. She did not put on the record the basis for this finding that they were grossly negligent. And they also say if it's essentially basically a sanction against us, this should be a last resort. And I agree with that too. Now, I've seen plenty of attorneys get into trouble, and you always try and stay out of trouble. You have a discovery leak, or you didn't turn over something you should have, or you told somebody not to answer a question at deposition and the judge thinks you should have. All those can lead to sanctions. But usually, often there's a warning first, and then there's, some financial penalty or something like that, and then it kind of steps up. So, let's take, for example, the Alex Jones case, and I know everybody has strong feelings on it. Put aside the feelings and think about the process. He ended up with his answer struck, so he was admitting liability. But that's not the first thing the court really can do, right? If that was the first thing the court would do, they'd probably just get reversed. So first they warn them, and then they issue a money penalty, and they do this and they do that. And eventually the nuclear option is you strike the pleading for the party. So if the first thing you do to the lawyers is throw them off the case, that's as extreme as you can get for these lawyers, I think. And so you need to have an order that has a basis to it that an appellate court can look at it and go, okay, well, here's why it wasn't, because there could be some extraordinary reason to do it. But where is that extraordinary reason? You shouldn't have to guess at it, because you are not only throwing them off the case, impeding their ability to represent somebody, but unlike a civil case, like I was just talking about, this is a criminal case, and Alan has counsel of his choice willing to work for him for free, and you're saying, I won't let you do it, and he's a qualified defense counsel on the record, then what has occurred that you're going to put on the record to say they cannot do it here? So I don't like that. And then she says they're gross negligence. Is that a legal standard for, I mean, what is that? Is that, you going to cite a bar rule, a case, something, anything that says if an attorney is grossly negligent, they cannot be allowed on a case? I mean, maybe you can say that. That would be a little new, and I don't know that it's the standard. I mean, are you going to say they're generally incompetent or whatever? And if the negligence is saying too much in a brief or letting somebody into the conference room that shouldn't have gotten there, okay, I hear all that, but is that really harming Alan's defense? I mean, maybe harming his defense more is what's happened since then, which is the new attorneys being put in and delaying the trial. So I don't know even what that standard is. And then the basis for it is in chambers. So, yeah, no, that's not good. And I put my last little thing here because if I'm going to quibble with what I think are compelling arguments, that they're calling the guy Rick, and it's like the defendant. We're not at a barbecue. We're at the Indiana Supreme Court. So I would, if I were writing it, I would have kept it with last names. But I understand what they're doing, and they're advocating. So, but I can't say that it's perfect because nothing's perfect. If you're looking for the membership link, if you're looking at it on an Apple iPhone, I don't think it's there because some fight between Apple and YouTube or whatever. So it's from the web browser or whatever, or Android. I think it all works there. Looking at some comments here real quick. Yeah. Okay. I think I missed some things here in the conversation you guys are having. Well, here's a good point that I think is directly on what I'm talking about. If the leak happened at Baldwin's office under his watch, why remove Rossi? At the very least, he should be allowed to stay. And so we all know this isn't about the leak; it's about the Franks document. Now, we'll quibble with you in this regard. I think it is about the leak and about the other thing. But I remember that slide I read a few minutes ago when the DA was saying this Franks brief was way past what should have been written to support a Franks motion. It was really an attempt to put this thing in a public eye and combine with the leak. That supports exactly what you're saying. Now, the judge, of course, tells defense counsel and Hennessy, this isn't about the Franks motion, but the defense didn't make that up. The DA had just said that. So I hear what you're saying. And I think a fair reading of this is probably all of it has finally got on her last nerve. But what does that mean? You made the judge mad or whatever, and the judge is going to do something to you. What is it? Because I think you can have different opinions of the Franks motion, but I don't think you can say they're not trying to zealously advocate for Alan. I just see that they are. And so I can see being upset about the discovery, but if you're using that to come back to the Franks memorandum, that's not really the way to handle that. So I hear what you're saying there. Yeah, there's a lot of confusion here. Not sure it's been proven what Rossi did or didn't do quite yet. He didn't disagree when Baldwin said he only wanted to be docked a day's pay. It's all. But you know what? It's up in the air because it wasn't put on the record, and it should have been put on the record. All right, so she's a judge. She shouldn't be using her opinions or feelings to make decisions. She should be following the law. And I agree with that. But what I'm saying is I feel like, to me, that getting mad about it is probably how you get the result, but it isn't justification for the result. I choose the getting mad over it and being really upset over these pictures coming out as overwhelming her judgment than say being part of, vast conspiracy or something like that. Not that I'm saying you're saying that, but that's to me why I think she would be making a misstep like that, if it is a misstep, which it does seem to be to me. So anyway, I agree with what you're saying is the short version of that. And I think that's a problem we've got here. But, you can be a judge and be mad about something and still do the thing the right way, right? I mean, the Supreme Court's not going to say, well, you did everything by the rules and this is an appropriate result under the facts and circumstances, but you were mad while you did it, so we're going to reverse this piece of it. I think the issue is did she really have the goods to disqualify them out of the case? And if she did, she should have put that on the record. So I think there's potentially two mistakes there, I guess. And that's why I say I think these are compelling arguments by Alan's defense side. Ask yourself a month later. Well, I don't know. I read the 100 years. Let me put this up. Sorry about that. So you're saying, ask yourself a month later why I'll replace that with the judge hadn't finished reading the 136-page memo, because I think anybody interested in the case had read through it at least once. And I've read it twice and made some notes for this other video that we were going to do on the members section that I'm behind on. But there was also a lot of things for her to read that, that we don't have, or at least I'm not privy to. It could be large attachments and things like that. But yeah, eventually you got to get around to handling it. So, well, thanks there to Gringo Latina for gifting out memberships. And there you'll find videos we do for the members section where the members vote on it, and the topic they pick, we kind of get into a deep dive and go into that. We've got a new one coming up. All right, so let me blast on to another slide here, but I appreciate all your comments. I would love to just read those and answer those, but I feel an obligation to move forward, or I'd be like, it's like I'm not reading a memo I should read. So the 311 removal actions. We talked about disqualification of the attorneys, and I think they got a compelling set of arguments there. Now they're asking or saying they want removal of the judge. And here, if I were drafting that, if I were going to quibble a little bit, again, because I think that what they wrote here is very good, they say a new judge should be appointed to avoid the appearance of bias. And then they quote a judge that says they quote a statute/rule that says a judge shall disqualify herself in any proceeding in which impartiality might reasonably be questioned. So if I were asking the Supreme Court to do something that's rare for them to do, I probably would use the shall. A new judge shall be or must be appointed, right? Then it needs to be, it has to be. And look at the rule. It says it shall happen, because should implies there's a range there. You should do this, you shouldn't do that, and you don't go to the Supreme Court to bust on judges for what it should be, but rather what is clearly a mistake. But they make the point, nevertheless. I'm still surprised this wasn't fleshed out more a little bit, because I think they have a good point for it in this respect. Hypothetically, if the judge makes some kind of error, the Supreme Court corrects it, it goes back down, and then you're supposed to put this in front of the judge, and then the judge rules on it, and then the Supreme Court can decide whether the judge made a mistake or not. They're not supposed to be guessing about what the judge will do. But this case is a little different, because this judge has already said, I won't consider these filings. I'll consider them as mistakenly filed, and they're not giving you any transcript. So that gives the petitioner an out here to say, basically, the judge has made this a nullity to wait for her because she's declared her intention not to deal with it. So I think, again, it's just an opinion, and you may have the same one or different, that they're correct that the attorney should be reinstated. And I think in terms of the judge being on the case or not, the only quibble will be whether the Supreme Court says, okay, we're going to order you, judge, to hear this and issue an order out, or they'll just go ahead and do it, because ultimately, probably this is the right answer here. If you believe Baldwin and Rossi should be back on the case, is it reasonable to say the judge needs to switch off to another judge because the bad blood is so much here that this just won't look fair to people? Because look, the rule says where the judge's impartiality might reasonably be questioned, and she's called them grossly negligent. She doesn't want to hear from them. She's said all kinds of things about them, that some of them may be correct or not, doesn't want to hear their filings. If they're ordered back into the case, would a reasonable person looking at this think, well, that's a fair situation? So I don't know about that. And you don't have to think she's the worst person in the world to say maybe she shouldn't be on this case. So now if you don't think they should be reinstated, then perhaps you don't think she should be off the case. But I think certainly they should be reinstated, and she probably needs to handle other things on her docket other than this case. So let's see here. Richard Allen's the one who was being charged on the 19th of October. Not allowing him in the courtroom when he was at the courthouse is a big deal. I can't argue with you. His counsel was either withdrawing without him knowing, and their own rule up there says you're supposed to give the client notice. Okay, so was that withdrawal effective? Were they breaking the rules or whatever? But, then Rossi comes back and says he's staying in. I mean, yeah, Allen shouldn't have probably been spirited away without being fully involved in this. It's just kind of weird. We traded some emails there a little bit ago, so I hope you guys are doing well, everybody in your family. So know that we're thinking about that. So I don't know. So I'm reading the chat here. I feel like a lot of people are saying, hey, they need to come back, and the judge needs to go, and I can't argue. Yeah, I mean, this is the short version of what I'm rambling on about because I'm trying to read what you guys are writing. If the lawyers are reinstated, that automatically means Judge Gull can't stay overseeing his case. It just wouldn't work. I kind of feel like that's fair, right? And you don't have to think she's necessarily the worst person on the planet to go, that's just how this needs to work out, right? If she potentially could have handled this better but didn't, for whatever reason she didn't, and created this level of error and conflict in the case, then, hey, move on down to something else on the docket and let someone else handle this case. So thank you for this. More free Southern Law memberships. That's crazy. So I'm going to have to do some good content for these people. So we've got so many new ones. Maybe. Depends on the algorithm, I suppose. All right. So let's look at the final argument in the 311 action, which is the trial date. So remember, this last original action to the Supreme Court was put these attorneys back in. That's awesome, I think. Let's get this judge out. Yeah, I see the logic there. And let's issue this speedy trial date. So they say Rick also signed Rick, you want another hot dog? Rick also signed a motion for speedy trial, and his attorneys plan to file it in early November. Now, plan to file it, it means you didn't file it. And you haven't filed it yet. So I think, here's what I think. I think if you're going to win on these first two arguments, which is put these new lawyers in and give us a new judge, I don't know that the Supreme Court should be ordering the trial date for a new judge who's going to come in for a motion that wasn't, in fact, not filed yet. So I feel like that's maybe a little more management of the case than the Supreme Court would want to do. Having said that, I didn't read the rule on speedy trial up there, but just thinking about it from a mandamus perspective, that I don't blame them for asking for this, but that seems to me the one the court would be the least likely to do, because if they give you the other two things, the new judge needs to come in and make sure everything's okay and stuff. And if you got may have a scheduling issue. So, maybe there needs to be 72 days instead of the 70 they're asking for. So I could see the Supreme Court saying, look, we'll give you the first one and maybe we'll give you the second one, but then we'll let this new judge decide what to do about that. So, wow, 5 more. That is crazy. Thank you. I think, hopefully the people will enjoy it, and then we can all be thankful for that. But thank you anyway, because I know the sentiment behind that, and I appreciate it. There's going to be a new judge. I would, if I were betting, I would be on your side of the table with that one. I hear you on that. Whether that's immediate or whatever, this case has turned into such a mess, I think. So there was an amicus brief filed. Okay. So I'm trying not to make this confusing. I'm trying to unconfuse it. 2 original actions in front of the Supreme Court. The first one was very narrow about documents being off the docket and struck from the docket, or attempted that. That was to get their stuff back in front of the court and get it acted upon. The second one's broader, and that's saying put these attorneys back, get rid of this judge, and let's get this case to trial. And this amicus brief is for this second one. I think it's for the second one. Yeah, because it's about, I think I did actually get it in order this morning. So it's much more restrained than Allen's counsel arguments, which, hey, that's fine because they're coming as an amicus, a friend of the court. So, they're going to bring a different perspective. It's not their job to argue every element that Allen's arguing or agree or disagree with that. They're just coming with the information they want to share with the court. But you'll see it dialed down a little bit here compared to, say, what the state might write or the defense might write. And they talk about the long history Indiana has of providing appointed counsel. And of course, they want that to be independent, and they, you have efficiency plans and things like that. And they talk about the lack of independence there is if a judge picks these attorneys and doesn't follow the plan that they have. Let's see. I think there was something I want to, that the judge should be operating inside the plan, they say, but the judge can go outside of it when the interest of justice require. So they're a little shy of saying the judge did the worst thing in the world here, but they are saying the judge didn't follow the process, and that calls into, can call into question whether these are going to be really independent attorneys, what was really going on here, why did the judge handle it this way. This is all of a piece with what just happened, because she picked two defense attorneys that are not from the county where the action is pending. Was that necessary? Who knows, right? I mean, well, I don't know. I didn't see any finding about that. And then she picked one of them who had been doing TV interviews, and I'm not slamming this guy. It's fine for him to comment on the case at the time he was doing it. But, one of the comments he made was about the forensic evidence, i.e. this unfired .40 caliber round that the law enforcement found at the scene, and the potential for law enforcement to put a witness on saying that this matches firearm that Richard Allen had, and saying, that can happen. He just says not all the time, but sometimes you can actually match that up. Now, that's subject to dispute, of course, but the general law in Indiana is that can come in as evidence. But putting all that aside, would you pick for your defense attorney somebody who'd been on TV saying, yeah, that's probably some pretty, that can be very good evidence there. Maybe you would want somebody who hadn't commented on your case at all publicly. And again, I'm not slamming him. He didn't know he was going to be appointed in this case, but you see people who are skeptical of the judge's efforts to throw Rossi and Baldwin out. And now here comes an attorney who's made a reasonably favorable comment to the state's case on TV, gets appointed. Had that happen, did they have a ball and they pull the names out of it like bingo? Some people are going to say, no, I don't think that's how that happened. So, I get the continued skepticism, and that's what this brief is pointing out. So, did the judge expunge the Frank's motion? I don't think so. I think what she said, let me correct myself. The defense said they filed it as a public document, and then boom, it wasn't public anymore. I would think that probably was the judge who did that. Now, it wasn't, of course, part of that batch of documents she said, I'm going to say, was filing mistakenly, and I want that struck even from the chronological case file. But yeah, I think it was out there, and then it wasn't out there. And the defense has said, this judge has taken things out of the public eye without following the rules. So it's not good. The main sin, of course, at this stage that they complain about on that front is her saying, I'm not even going to consider what you're filing anymore, and I don't even want it in the record. But they're certainly pointing back to these sorts of things. And I don't know. I think if you as long as you're following the discovery rules, because they do have orders in the case about how to handle the discovery and the information being traded back and forth and stuff like that. I compare it to like the Koberger case, where I think the state and the defense are behaving in a highly professional manner on both sides as how they're litigating the case in the court. That's my opinion. And there's a lot of information in that case that is not being shared with the public. Lots of requests and things going back and forth on the evidence side that may be important or may not be, but you don't see it because it's all being kept secret. And there was some dispute there that they had agreed to, the parties, to a greater level of secrecy than the court should be allowing. Having said it, again, I find their behavior on both sides highly professional, and that judge out there, Judge, to me seems phenomenal. And I'm not about insulting the judge here, but this sometimes they make mistakes and they're human, and we're allowed to think that. And I think this is one of them. So, let's see what's more about that. Yeah. And there's some discussions about the facts of the case here, which I appreciate that. I won't do that in this stream because I'm trying to keep it down to pretty much what's happening at the Supreme Court and getting to, when we get to the end of it, what is the potential outcomes from this? Because really we ought to be, if we're going to debate this case, debating the state of the evidence to the degree we know it and the quality of the theories that the state has, and then what the defense says in contravention of that, whether it's the state not proving their case, they say, or having an alternate theory like they have. That's what you'd want to look at, and eventually the jury will, but with a full view of the evidence. Anyway, let's rocket back onto here. Yeah, Judge is a good one, I think. A good judge, and that's what you want. We can all have our opinions on whether somebody did it or not, but I think in any of these cases, what you want is a quality process, because that's the best as humans that we can do, is have a quality process that applies to people generally. You don't break the rules to help somebody or to hurt somebody. That you have a system, and that can increase trust in what's going to happen in the justice system. Whereas if weird things are happening and the public can't see what it is, the trust goes down. So let's see. I put a couple things in here. Let me get on this bottom screen and I'll be able to read it more easily from the records that are filed up at the Supreme Court. And what's on the left is part of an affidavit from the attorneys, Rossi and Baldwin, but it has some information in it. And they're talking about, on the phone conference, Judge Gull commented she assumed the defense's request for a discovery deadline was intended to support a request to continue the trial date out of January. And they said, no, we don't want to do that. We want to take this case to trial in January, which is great, right? I mean, if he did it, let's get the verdict. And if he didn't, get him out of there. Because if he didn't do it, this is even more of an injustice than normal, because he's sitting up there in prison rather than jail. So, whichever side of that you're on, I think to the degree you can get this trial done in a fair manner, the faster, the better for everybody. Then they say the parties participated in a telephone conference with the court on the 10th of October to discuss the matter of Westerman surreptitiously taking photos of crime scene, photos and deposition exhibits prepared by the defense. And the state suggested that the disqualification of defense counsel might be appropriate. And in response, Judge Gull indicated that she was leaning towards disqualification, but didn't get into a rationale for it. So there's a little insight into what was going on in this phone call, because I figured something had to be going on, but what was it? Because we started to see all these actions and ramp up to this hearing, and then Hennessy coming in and saying, don't throw them off the case. If you have to sanction them, do something less than that, which that sounded reasonable to me. But, and again, if you think letting those pictures out is terrible, I'm not saying it isn't. Okay. I'm not saying it isn't. I'm saying you have to think about how to respond to it and what's the appropriate level of response and how to deal with it. So if you think they did it on purpose, then you need to have a finding for that, because if they were doing this stuff on purpose, people might have a different, and you could show it, that people might have a different view of what the judge is doing, but I don't think that's been shown. As a matter of fact, they have this affidavit from Westerman, who's the guy who did it, saying, he was waiting for Andrew Baldwin, and he went to the conference room table and sees this photo evidence, took pictures of them. He didn't have permission to do it. So that sounds like, Baldwin didn't do what he should have done potentially to secure this evidence from people who might be wandering around his office. And that's not the best. But from this, can you say that Baldwin and, say, Westerman or whoever, that they all conspired to get these photos out there so that it would support Allen's case? I don't see that. I just don't believe that of these guys. I don't believe that. Do I believe they're trying to push their theory of the case into the public when they get a chance to do it? Yeah. I don't really hold that against them. So, but why wouldn't they do that if they could get away with it? If the court didn't like the Franks motion, they could have had a hearing request to be filed under seal or redacted. There are a lot of ways that could have been dealt with, for sure. Again, they seem to be handling it okay out in Idaho, and there are ways to do it. I mean, you can file something provisionally under seal, and the court can rule on it, this, that, or the other. They didn't do that here, and of course, I guess the theory is they didn't do it on purpose because they were going to put stuff out in the public that wasn't allowed to be in the public. But in my mind, let's say they disclose something in the Franks motion they should be in trouble for disclosing, and you want to punish them for it. Well, then call them into court and say, you did this and you knew you did it, and here's your sanction for doing it. Don't do it again. you don't just remember it until later without commenting on it, right? Or at least that's not my experience if somebody does something like that. This is first time I'm actually suspicious of a conspiracy is the comment. Well, I hear you on that. I don't myself see, like this unified conspiracy going on, and I'm not saying you're saying it's all of them, but it's not good. And so I think that's why some of these things have to happen. Like I know a lot of people on here feel pretty confident that he didn't do it, and I'm not confident he didn't do it. But if you're on the confident he didn't do it side and you're saying he needs a fair trial and a fair process, I'm right there with you on that. Absolutely. Whether I see the evidence leaning one way or the other right now doesn't sway me to whether this guy deserves a fair trial here. And I don't see the basis to throw these attorneys out. Of course, if I'd been the judge, I wouldn't have, I would have tried to not have him kept in prison too and put him in jail. Koberger's in jail, isn't he? He's not in some supermax prison. So I haven't liked some elements of this as it's gone along. But that doesn't mean I swallow everything Baldwin and Rossi says. I mean, I'm not accusing the Chad of doing this, but some people do it. If they pick a side, whether he's guilty or whether he's innocent, then you see it through the lens of everything my side says is completely great and everything the other side says is totally wrong. And that's never life. So, if I see something, say with Baldwin and Rossi, I'm like, that's over the top in this filing or whatever. I'm still looking at their core argument. And same thing for these petitions to the Supreme Court. And the core argument is, did the judge have a basis under the law that allows her to throw these lawyers out and not even represent this guy for free? And then also, did she follow the law in terms of how she issued the order to put a basis on the record? And I think they have a pretty good case there to say that they're right on that. Yeah. And so here's some skepticism. Okay. So the defense is full of crap. There's no way Baldwin's friend was responsible for the leak without their knowledge. So let's say that's true. And I don't know it one way or the other, but I can understand why you would think that too. That's not really grossly negligent there, isn't it? It's an intentional thing there, right? And remember the DA said in the earlier slide, this is all part of their plan to put these things out there. I can't say one way or the other on that because I haven't seen those pictures and I don't want to see them. Not because, I'd like to see what it would take to know what happened in this case, but not the evidence that's supposed to be secured and not with the subject matter that's in there. So, but putting those out there and to the degree they got around or whatever, is that really helping Alan's case? I don't know that. I just don't know how to feel about that, but I can understand what you're saying there. But I think the point is, if you have an opinion that they did it on purpose and you're the decision maker, i.e. the judge, get on record what the grounds are for what you're doing. And where is that? Show me the order where it's laid out. They did A, B, C, and D in the order, and that warrants this remedy right now. Boom. So I don't know. Okay, I don't know. Now I will say about this F tree, the picture I saw of it, I don't see an F in it, but maybe I'm not the visionary I need to be to see it, but that doesn't mean anything. I haven't seen any of the other evidence. So whatever does that make, right? I guess we'll just have to see. Yeah. Without a fair trial, there's no justice for Libby and Abby. And that's a critical thing here. So let's talk about the hypothetical, because we're just making this up right now because we don't know whether he did it or he didn't do it. But let's say he didn't do it, but he gets convicted. That's terrible. That's terrible for the families, even if they think they got the right guy. If he didn't do it, because that means whoever did do it is still out there. So now you got 2 victims, or 3 in this case. You'd have 3 victims in this case at least. So to the degree that it can be done, you want the system to have the accurate result, right? If we were all knowing, we wouldn't have to worry about any of this. And we're not, and we know we're not. So in theory, we tilt the scale a little bit to say you have to find beyond a reasonable doubt that he's guilty. And even that tilting of the scale for the defense, is counterbalanced by the fact that the state has a lot of firepower, a lot of investigation assets and things like that, and sometimes more than the defense. And at least in the old days, people would often think they wouldn't have arrested this guy if he didn't do it. So you had to have this innocent until proven guilty to also remind everybody, scratch all of that. Let's just take it all from ground zero. Until this guy is proven to have done it, he didn't do it for purposes of this trial. It's on the state to prove it. And if they got the goods, they got it. And if they don't, they don't. So Yeah, the judge should have brought him in. So that's the thing. So there's two potential errors. And one is, what if she doesn't have a basis? And if she didn't have a real basis to kick them off, I think we can all agree she has no business kicking them off. But the second problem is she does have a good basis, then where is it? And that's also a potentially fatal error, I think. So, well, here's a little summary chart. I think we said most of these things. In my opinion, the defense is not clean. They exposed court-protected materials to unauthorized people at least twice. And one of those times included photographs of child murder victims. That's bad. Now, that doesn't mean to me that Baldwin or Rossi are bad people or aren't good defense attorneys, but that's not good to do that. But like we just said, the issue is whether does this warrant disqualification for gross negligence as his defense attorneys. It's his defense attorneys. If it makes you mad they did that, I respect that. But does that mean at trial they won't be good defense attorneys? Those things are not necessarily together. So if you want to punish them for that, then you can't even really say they're grossly negligent. If you're saying they're engaging in a campaign to strategically leak things to help Alan, hell, that's not negligent. That's awesome if they can get away with it in terms of doing all they can for their client. But if you're beyond the rules, then you'd be punishing them. That's different than gross negligence. So basically saying they're bumbling. So were they bumbling and letting stuff out that hurts Alan's defense? Or were they masterminds trying to manipulate public attention with a strategic, intentional plan and need to be off for that? You got to pick a lane here and get into it. And I think that's what the judge should have done, is go on the record and say, as the judge, I find they did this, this, and this, and therefore I want them off the case. I didn't see that. So that's what I got on that. I'm seeing E, but that's just me. Yeah. We'll have to see, right? Because I agree. I saw probably some of the same analysis of that F-tree that some of you guys did, because I watched it on a YouTube video, but it's only one facet of what they have to say. And I will say they're more Odinists around than I would have guessed, and including the guards, at least being Norse pagans, if not necessarily Odinist, although I think one of them had an Odin patch on. So, I'm not going to trust my imagination to be the decider of whether the defense has a good theory or not, or the state for that matter. So we'll see. Here's that point here. It was not strategical. They leaked it to a convicted felon. That is admitted Odinist. How easy do you want it? Okay. I hear ya. Yeah. The judge was mad that the lawyer hired a lawyer. Now she's hired a lawyer. I mean, there are like a lot of lawyers in this case at this point, right? Yeah. Yeah. Well, right. Here's a great one. I think I'm looking forward to reading the transcript from the in-chamber meeting. So at this point, probably everybody has an opinion on how this ought to go. Either you think they did, they engaged in such wrongfulness they should be off the case, or you think the judge overstepped. But nevertheless, up until this last hearing, I would have said it's really important to know what happened on the in-chamber meeting. But wouldn't you think that with the defense counsel asking for it, that if it really supported what the judge said, she'd be like, oh, hell yeah, then here's your transcript, baby. Look at what we all said in it. Here's you saying how you want to withdraw the case, whatever bad things that she thinks would be about them. So if it's going to be confidential at this point, it's confidential for whose benefit, with Alan's defense counsel saying we'd like to see this transcript, right? If it justified the court's order, what's the problem with going ahead and producing the transcript? And maybe she will. Yeah, there is a tort claim notice. And I think at one point they said they thought she was mad about that. So I don't know, right? That transcript might show some of that, right? Public defenders are not allowed to even just quit. Now, having said that, no matter who you are, if you are an attorney who appears in a case, in the litigation, you file an appearance, you don't leave until the judge gives you permission to do it. Now, it might even be tougher for a public defender up there, I'm not sure, but they filed a motion to withdraw and she granted it. So, or they didn't file anything. She said one of them orally said he was withdrawing and she granted that, and the other one indicated he would and would be filing something. And then when he did file something, she didn't like what he filed and said, I'm not going to look at it. So, Attorney Baldwin hired a lawyer to appear on his behalf on the issue of sanctions and disqualification. So that was really weird to me when Baldwin showed up with an attorney, because I've seen or been in sanctions hearings and things like that, and haven't seen the lawyer have to go out and get a lawyer. So I'm like, what is going on here? Under the circumstance, I think it was warranted because clearly the judge and defense counsel reached a point where they weren't going to communicate well anymore. And with Baldwin seeing what was going on and feeling the way he felt about it, I think he did the right thing there. So that's a very weird thing to have happen. And this case warrants it because there's so many weird things happening. So you got a rare situation of this writ of mandamus, and this is a weird, rare case. And to me, it warrants it. It does. You also see in one filed down in the Murdaugh case, which hopefully I'll cover that a little bit tomorrow. Not as bizarre and bonkers as this one. This has all gone crazy. So see if So let's be realistic. The defense was kicking the prosecution's butt. State was not ready for trial. Well, I hear you there. Again, I think the thing is, I think they were zealously representing this guy, right? If you ask me right now, do they really think he didn't do it? I might even say yeah to that. And, you know, most people did it when they're charged with it. Most people. You can't say all the people because that's not true. But you know, most of the people that you're going to defend did whatever it is. But in a serious case like this, you would put it the best defense you can, whether you even make a decision whether you think they really did it or not. But they sure act like here they think he didn't do it. So if they're faking all that, I think they maybe have me fooled on that. Let's see. They already made their move with a Frank's motion leveling the playing field. Then to put your entire case in jeopardy to purposely leak these photos. Yeah, I mean, that's good logic, I think. I agree with that because I'm not seeing how leaking the photos in the way that he did really helps Alan, per se. I mean, it would, I guess, if people saw in that the exact placement of these sticks and things that really looks like, some kind of Odin thing or whatever. Maybe then. But they already said all of it, and so I don't know. I hear you on that. It wasn't a very good, effective leak in that respect. And who are they trying to convince? I mean, I haven't seen these pictures. Maybe some of you have. Probably almost anybody who would be on the jury hasn't seen it. So that's different than a Frank's motion, which about everybody talked about the Odin thing, right? So there is DNA evidence. Yeah, but we don't really know anything about it, right? So again, well, I think the circumstantial timing looks really bad for him. The only forensic thing that I'm aware of that ties him to this case or to the scene of the crime forensically is this round, and that the concept, the weight of that, and whether it's admitted, the weight of it and all that, it's all for the future. But I know they said it, there's DNA evidence, but it's not what you think, and they have maybe some other things too, but. If they tie anything in any way Richard Allen to the case, I just don't know about it. Why wouldn't this judge just step down? Well, good question, but oftentimes people don't. I mean, maybe she feels like what she did was appropriate, and if she does, then in her view, he's got new lawyers who are good lawyers. Let's move on without these guys and get this case going. That may be how she feels about it. And that's why you have an independent court like the Supreme Court, who, if it's an extreme circumstance, can come in, hasn't been involved in this case at all, and look at it and go, okay, was she in her lane and doing it right or not? If they thought he was guilty, they would have withdrawn and kept going. Okay, and maybe so, but I mean, often defense counsel will work really hard on cases even where any reasonable person would be like, that dude did it. That dude did it. I mean, that's their job, and they're professionals and take it seriously. So I respect that. That's not what I have done in practice, but I respect it. Yeah, here's a good comeback to that. Why did the judge do that? For the same reason she didn't realize how bad it looked in the first place. They confirmed they had some type of DNA and hair evidence, but don't know if it matches Richard Allen. And it seems like it'd be in the PCA, right? So, of course, unless they hadn't tested at the time they made that PCA. But the other thing that was really weird was, if you remember, they said, well, we don't want the PCA released because this is an ongoing investigation. And at the time, the state was like, well, there could be more than one person involved. And they charged him with felony murder, not the actual commission directly of the murders. So I certainly thought that they thought there was somebody else. And then when I read the PCA, I thought, well, the only reason they didn't want that out there is because they don't want this second person to know they really don't have any evidence on them right now. And maybe they were hoping Alan would rat this person out. So if Alan was involved with it, and, you know, I still had some other actors in my mind who have been circling around this case, who were nasty people who I thought would have been involved in this if anybody was, that maybe would be tied in, but none of that's panned out. And then we get this Odin thing. So I don't really know. Yeah, none of the DNA matches RA. Certainly no indication that it does, or necessarily it's anybody. Because, you know, if they found relevant DNA out there that is not his, the defense is going to make a big deal out of that. But on the other hand, if that were true, you'd think you might have seen that in a Frank's motion too. But I don't know. I don't know what all they got. No digital DNA. Yeah, I'm not aware of it, of anything that links Alan to the case, only this bullet. So I think if that were known, that there was something that linked him there, we'd probably have heard about it. But on the other hand, I think if there was something concrete that linked somebody there, we'd have heard about that too. I think the defense is kind of making that point, that the lack of evidence in their view was an indication that the crime scene was kind of handled better than one person could handle it, right? Yeah, too many rabbit holes. Has the defense seen all discovery? Good question. I don't know the answer to that. In some discovery, of course, it's still things being created as you work through issues and stuff, but I don't know the answer to that. McLeland asked for the attorneys be removed. Was he being objective? No, of course not. No, he already thought poorly of them. And, you know, if you think the guy did it, then you might not like some of the tactics the defense is using. But then guess what? You're not objective at that point. You shouldn't be judging whether they stay in the case or not based on whether you like how they argue or what they argue. That should be nothing to do with whether they stay in the case or not. You know, what should have something to do with it is whether Richard Allen wants them as his attorneys or not. If you can't even convince all the cops on the case you have the right guy, how are you going to convince a jury? They're all good thoughts. It's not the easiest case in the world. Again, which I won't drag you through that. If we were going back through all the facts again, I'd give you my theory and you could rip me apart for it. But I feel like there's a pretty good case on the circumstantial timeline. But you know, the defense has got a lot of things to say about it, and it's all worth discussing to test that. If I can't give you my theory of why I think he did it and talk to you reasonably and rationally about your contrary arguments, then I probably don't have a very good argument, right? Yeah. So, all right. So that's what I had on this. So if anybody's got any questions, because the specific point of this video was the Supreme Court actions about that there's two actions and that's what they're for. The first one was kind of preliminary. The second one is to the heart of the thing. And in short order, the Supreme Court is going to be dealing with this in one way or the other and what the possible remedies are. So that's get things back on the record, put these attorneys back on, they say, get rid of this judge and give us a fast trial. I don't think they're going to go 4 for 4, but I don't think they're going 0 for 4 either. And I will also be interested when the transcript of the private meeting comes out. And I think Odinism strategy is ridiculous. Makes me wonder why the state is so worried. Well, I think a lot of things depend. And if you put if the jury were to say, I don't buy this bullet thing, that's not enough for me. And holes in the circumstantial time frame, and because that's really what you have against the guy. If you could poke some holes in that, then I guess it would be, you're going to get a not guilty verdict. So that's probably what they're worried about. Now, somebody who's looking at this from the other direction is going to say, well, they're worried about it because they don't even know for sure they got the right guy. And even they thought there were more people in on this. So how does all this even stack up? And I hear all that. Now, having said all that, if it were truly a big fat conspiracy and a smart conspiracy, then why wouldn't you just blame it, say, on Ron Logan? Because he died, right? And he looks kind of like the bridge guy picture. It was on his property. His cell phone was allegedly around the time. He lied about where he was at the relevant time. That's some pretty good evidence to make him look suspicious. So you can say, well, he did it, but we'll never be able to prove it because he's dead now and we can't, we're never going to be able to get a confession out of him and close this thing out. And all the Odinists are protected at that point. And to pull Richard Allen out, if I were going to pull him out just for the hell of it and then try and pin it on him, I would want something better than an unfired cartridge that only has a tiny scratch of it from the gun. If I were going to conspiracy theory the hell out of this, I would try and get some of his DNA and put it there, something that belonged to him, smear it on something, something better than a scratch from the inside of a firearm caused by an extractor. So I don't know. Yeah, I mean, you got the consequences of this leak. Somebody's mentioning that, and it is terrible. But again, if that's your issue and you're the judge and you think that the defense was the proximate cause of that, get it on the record is my point about that. Let's see here. It was recorded. Yeah, the hearing was recorded. Well, somebody said, does the AG represent the court reporter? I'm not aware of the court reporter needing representation, because I think the court reporter is just standing by and saying, well, hey, look, when a court tells me to make a transcript, I'll make a transcript. And so that might be the Supreme Court, or it might be ultimately Judge Gull. I don't know. Let's see if there's anything I can contribute to. All right. So tomorrow, when I talk about this case, it'll only be the briefest summary out of what we've all explored in a great detail here, but certainly got some interesting thoughts from the perspective that you guys have brought out, and information too. Everyone has a lawyer except the defendant. There's like 18 billion lawyers for Allen now, though. Some of them kinda, some of them for sure, some of them are appellate or whatever. It's all crazy. But he doesn't have, right now at least, on the record, the lawyers he wants. Yeah. What about the lack of findings, due process and certain findings? Surely she had known that was a mistake. Well, I think it's a mistake. I agree with with Allen's side on that. I don't know why she thinks that. It's not like I researched it super deeply, but if you don't give the appellate court the basis for your ruling, how is it reviewable? And that can be a fatal defect sometimes for orders. Yeah. They never set up Ron because they believed the clients were involved, and that didn't pan out, and he was well cold. But I see you still could have gone back to him, though, right? And I remember when I looked in this case originally, one thing I did think, and of course Richard Allen was on nobody's radar, was that there are so many sleaze bags in close proximity to these poor girls that the choice of garbage that could have done this is large. It's sadly too large. There shouldn't be a lot of people around who could have done this, who you could look at and go, well, that's the person who's living a lifestyle and with a history that I think they could have done to these girls what was done, but there were. And I think that's true in too many places, not just there. All right. Well, I have to get up super early in the morning again to get ready for this other one, because there are some interesting cases to other cases to look at, and also a job at current. So again, thanks for everybody for coming by and talking about this case with me. The goal was to tell you about the Supreme Court stuff. Hopefully we've accomplished that. You guys expanded the scope with some really interesting observations, and I appreciate that. Well, have a good night, and if I don't talk to you tomorrow on the other stream, have a good weekend. Thanks, bye.